All this is because of HJR 192 of June 5th, 1933, Public Law 73-10 and all associated policies, codified at Title 31-5118, which is the rescission of the gold clause in contract, and the government demanding the turning in of the gold. This is where it gets tricky. This is where a lot of the sovereign community, they have a foothold. Because you are guaranteed a Republican form of government. To have a Republican form of government, you need gold, you need people, you need land, and you need money. Money is gold and silver. It always has been and always will be. That is real money. It's money of exchange. The money that they are utilizing in their system is called money of account. It is dealing with accounting because it is debt currency. They removed us and took us off the gold standard in 1933, even though we were guaranteed a Republican form of government. So the question, because what we're trying to do is you're trying to establish the fact whether or not the government has a duty to discharge debt. All right, y'all go out there and issue instruments and try to give them to people. And well, do they have a duty to take it? You say they have to take it. Okay, well, if they have to take it, then prove they have to take it. How are you going to prove that they have to take it? Why is this question being avoided? And it's not just because you say so or just because, well, what happened? No, where is your evidence? Where is your verifiable evidence that can be authenticated and put into evidence, and somebody can testify with firsthand knowledge under penalty of perjury? We got a public record that speaks for itself. We got the congressional record of 1933. We can use that. But where is the duty derived from? If there was some sort of possible way, a pathway to establishing whether or not the government has a duty to discharge debt, it would have to probably come through the public trust doctrine. And it was going to be an equitable remedy, and we're going to utilize the constructive trust. That would have to be the remedy that you would have to, seek, a constructive trust in equity, because it's unjust enrichment, because they have taken the gold and now they are demanding. Now, what if we decided not to work in their system? That's the question. Okay, I don't have to. That's why a lot of y'all are confused, because you think you trapped into working in their system. And essentially they did trap you into working into their system. And that's the gripe, I think, where people are not feeling where they're really free, because they really can't conduct business or engage in commerce without any type of government regulation. And that's a legitimate concern. That's a legitimate gripe. That is a legitimate question that people can ask. That's legitimate. It's like, look, I have privacy. This is something even you can get into an argument with an AI computer on, because this is where it really will reveal that, yeah, the AI computer has limitations on it, or it's been, got some blockers on it. And you will reveal that because you say, well, look, man, let me ask you a question. I'm guaranteed a Republican form of government. Y'all took all the gold in 1933. You saying I need to shut up and be quiet and just accept it. I uploaded Perry versus the United States, the congressional record of 1933, Financial Accounting Standards Board Statement number 95, because on page 21, it tells you that they create money through lending, the banks. The affidavit of Walker Todd, he's an expert witness, and he attested under penalty of perjury that the banks don't loan you any money. And if they extend credit, they should expect credit back. So all of these things, and that's an expert witness. Okay, so now when we synthesize all of this information together, we come up with a litigation pathway. And we could say that it is theoretical because it hasn't been tested yet. However, it's something that I want each and all of you to think about, because you are interested in discharging debt. So I want you to think about this theoretical litigation pathway, because all roads lead to court. Now, ideally, when you're discharging debt, you want to do everything privately and you don't ever want to go to court. But you always have to anticipate going to court. That's why you send all your correspondence either certified or registered mail whenever you are sending a negotiable instrument through the mail. If you created it on your computer or not, you should look at your negotiable instruments as real money. Is value. That is, you keep your 3811 forms. Your 3811 forms are your green forms. You want to keep those because those are evidence. Those are your witnesses. When you send something, you ask for return receipt requested. That's going to be an exhibit when you go into the courtroom. You're going to establish on the record that they did receive the correspondence in a timely manner, as well as the fact that they didn't respond in a certain amount of time. That's establishing that you are approaching the court of equity with clean hands and with good faith. That's what that demonstrates. It demonstrates that you've acted in good faith and you've acted with clean hands in your attempt to acquire or achieve resolution to the matter, some sort of amicable resolution to the matter. This should be reflected also in your cover letter or your correspondence that you are mailing off. It shouldn't be aggressive or anything like that, but it should use language as, this presentment is hereby presented for full satisfaction of this obligation. My records are showing a statement of account of zero balance, and you're going to want them to return a statement of account to you within 10 days. Or you want them to identify some sort of defect in the instrument and allow you an opportunity to cure. So if this is unacceptable form of payment, please state why it is an unacceptable form of payment. Lawfully, you're going to state that. Now, this is where things get tricky because they understand the law. This is where you're going to really start seeing that they really understand how the system operates, because either they won't send it back to you, but won't apply it on the account, but they'll keep it because they know if they send it back, well, if you didn't take a negotiable instrument, what are you going to take? Okay, because there isn't anything else but negotiable instrument. If they don't, that's why you have a UCC 3-603B. Because if somebody tenders a negotiable instrument, they won't take that. Well, what else can you give them? Because everything in the system is a negotiable instrument.